So why don't we get started? Hopefully we'll get a few more to join in as we begin. Good afternoon, everyone. Those of you that are on the call, thanks for joining us today for what we hope will be an interesting and engaging panel discussion on receiverships. My name is Keith Chulumovich. I'm a managing director at O'Keefe. For those of you not familiar with O'Keefe, our firm, we're a strategic advisory consulting firm based in Michigan with offices in Bloomfield Hills, Grand Rapids, and we have one out in Phoenix as well. I am part of the Turnaround Restructuring and Financial Advisory Services group, and I will be moderating today's panel discussion. I've not been a receiver, I'll be the first to admit that, but I have acted as a CRO in bankruptcy proceedings, and prior to joining the firm, I was in various senior financial roles, and I made sure no receivers were ever inside my door. So I've got that going for me. But before we get started, I want to acknowledge and thank our nearly 40 sponsors who support our TMA programming. Amanda, if you want to flip the screen, and this will just save me of reading all the gold, silver, and bronze sponsors. Thank you all very much. Those of you on the call that are not sponsors, you should strongly consider it. And you can get a hold of Amanda to find out more about how to do that. As many of you are aware, receiverships stem primarily, I'll say primarily, out of state court. And if used properly, are a valuable tool in insolvencies and to some degree restructurings. Today, we're going to look at receiverships from the perspective of from the creditor, from the legal advisor side, as well as the actual appointed receiver, to get different perspectives on the topic. Our panel's got varied backgrounds and experiences, and I think you'll enjoy hearing from them as we go through this. I would like to start and have them introduce themselves. I see Traci on my screen, so I will start with Traci Quarter of Mercantile.
All right, thank you, Keith. Yes, my name is Traci Quarter. I'm with Mercantile Bank of Michigan, first vice president of risk assets there. I've been in commercial banking for 25 years, with the last 20 years, and specifically in commercial loan workout. I have dealt with receivers over the course of time, but it's been fairly minimal in terms of different workout strategies that you can employ. But certainly one of the tools in our toolbox. So looking forward to talking about it today.
All right, thank you, Traci. We have Kay Kress as well, who's sitting there. All right, Kay, why don't you introduce yourself?
Thanks, Keith. Good afternoon. I'm Kay Kress. I'm a partner in the restructuring and finance group at Troutman Pepper. Some of you may know us at our predecessor firm, which was Pepper Hamilton. I've been practicing for 35 years. I'm actively involved in the American Bar Association Business Law section. I'm a fellow in the American College of Bankruptcy. I'm a fellow in the American College of Finance Lawyers. In my first 10 years of practice, I was a creditors committee lawyer, and we practiced on a national basis. And then I morphed into a secured creditor lawyer representing servicers and special servicers in the franchise arena and in commercial backed security loans.
Fantastic, thank you, Kay. And then last but not least, we have Jean Kohut. Hopefully, Jean, I didn't butcher your last name.
Yeah, thanks, Keith, and thanks for all of you for joining us today. My background is I spent the latter part of 30 years as a restructuring lawyer in the Detroit area, and 20 to 25 years of those have been spent in the fiduciary side of things as a bankruptcy trustee out of the Eastern District of Michigan. I've served as a Chapter 11 trustee, plan administrator, post-confirmation trustee, court-appointed receiver, assignee under assignment for the benefit of creditors. So, I'm with the firm Riveron, which our predecessor, Conway McKenzie, was acquired by Riveron a couple of years ago. We have 600 professionals across the country, 12 different offices. I lead our fiduciary advisory group, which is precisely the area that we're here to talk about.
All right, thanks, Jean. I'd like to submit to the group that Jean is more than qualified to speak on this subject. Thank you.
We all are.
like most panel discussions, we have some, I'll call them canned questions. Some will be free flowing. But you as participants in the audience, feel free to use either the chat feature or the Q&A box if you have, questions or information you'd like to learn more about. And we'll either address those at the tail end, or depending on the question, I might insert it in the middle of the discussion. With that being said, I'd like to come back to our panelists a little bit and just as we talk about receiverships, more specifically their involvement and experience with receiverships over the years. So if we can start again at the top with Traci briefly.
So again, in my 20 years of commercial loan workout experience, I think I could probably count on one hand and certainly on two the number of times I've had to have a receiver appointed. But again, the instances in which that happens are varied. There wasn't one particular dynamic that called for it. We've had everything from commercial real estate holding companies to manufacturing, service providers, retail. There isn't any one type that fits a receivership best. Individual circumstances certainly dictate.
Okay, great. Thank you. Kay, how about yourself?
Well, prior to the passage to the Uniform Act in Michigan, I exclusively dealt with receivership in federal court. Never wanted to go into state court. Still prefer federal receivership for many reasons. In 2012, I was asked to be the delegate for the business law section and the drafting committee for the Uniform Commercial Real Estate Receivership Act. I served on the state bar committee that promulgated the rules that were passed by the Supreme Court of Michigan prior to the receivership being passed in the state of Michigan. I've represented lenders and borrowers and a tenant in a tenant landlord dispute since the passage of the act. And I've also been involved in a divorce proceeding where there was a receiver appointed over an individual in the divorce proceeding who had many business interests.
Okay, great. Gene.
I'll concur with Kay in the sense of the federal receiverships, and there's a number of reasons we'll get into later on as to why they tend to be a better forum, and obviously not in all circumstances. But I think the one interesting thing, at least, and I think we'll talk about this as well, is that there has been a consistent movement, I think, over the last few years with regard to alternatives to Chapter 11. And I think that has really piqued the interest of practitioners simply because for a number of reasons, whether it's the cost or, committees or other issues that come up in the context of bankruptcy that I think, has piqued the interest of other fiduciary roles. And I think from that perspective, having somebody that's experienced in the fiduciary side of stuff, the independence, I think is important, whether you're the lender, you're representing the secured party, or you're representing an unsecured party. So I think all of that is relevant to the importance of why we're having this discussion today.
Okay, I appreciate that. Thanks, Gene. And Kay, I'm gonna start with you, I guess, and just for the benefit of our audience and me, actually, just a little bit of the history of receiverships. You can go far back as you want, keeping time into consideration, of course, but just the definition of what it is and where it started and where we are now.
Well, receivership historically was used as a remedy, generally by secured creditors. Again, I mentioned I liked federal receivership, and I used that remedy because if I had a borrower, if the client had a borrower where we couldn't get control, we thought there was something bad going on, you could use federal receivership, get into court, get a third party in there. You could sell the business as an operating company. So that's the history. It comes out of federal common law. And the definition comes from Clark's on Receivers from 1959. So it's been around for a long time as a remedy. It's defined in the Michigan Act, and it's a very similar definition to that which was promulgated in 1959. And the act says that a receiver means a person appointed by the courts as the court's agent and subject to the court's discretion take possession of, manage, and if authorized by the act or the court, order, transfer, sell, lease, license, exchange, collect, or otherwise dispose of receivership property. There's a patchwork of receivership law by states. We have this map and it shows like a quilt with all kinds of different. So it runs the gambit. You have, when the Uniform Law Commission started its study and its drafting, it looked at all the receivership statutes that were out there. And in some states, Florida being one, although they've now passed the Uniform Act, they had one line in the statute. So all of their receivership law came out of common law or just their practice, what they did in the courts. I know Indiana, it varies from county to county. You have to look at the county rules to see what the receiver is. In Wisconsin, it's tied to the assignment of benefit of creditor statute. I don't quite understand it, but I know I had to look at it for a client and ended up getting Wisconsin lawyer involved because none of it made any sense to me. It was a very strange concept. So that was the purpose of the Uniform Law Commission, to try to put together a uniform law that all states could pass, so that, like the Uniform Commercial Code, which is where it came from, the Uniform Law Commission, all states would have similar statutes and reciprocity, and they could look and you could have ancillary proceedings. So that was drafted. It's now currently it's in 10 states. It's been passed in 10 states, one of which is Michigan. It's been introduced in Rhode Island. You also have Washington State and Minnesota, where at the time of the drafting have very sophisticated bankruptcy-like statutes. And they probably will never adopt the Uniform Act because they had spent a lot of time on their own statutes prior to the Uniform Act.
I mean, God, it would seem to be confusing. I mean, how many times are the differences so great that I mean, is there a difference in the outcome, or is it just subtle differences on, minor issues?
Oh, it's a difference in the big controversy when we were drafting the statute was the ability to sell free and clear. There were many states, Colorado being one, because the drafting committee had uniform law commissioners, it had judges, it had receivers, it had ABA delegates, it had lots of people there. And there was just a lot of resistance to the ability of a receiver to sell free and clear. A lot of resistance in California. There was some weird California case that said a receiver couldn't sell free and clear, but historically it's been allowed, and it is allowed by federal statute and federal courts. The problem with getting federal jurisdiction, and the benefit of if you have a client with collateral in several different states, federal statutes will allow the receiver to take possession and control in those states, and actually has a statute about registering in the county where the property is located and to take possession, and the court has jurisdiction. But you have to be able to get diversity, which means the plaintiff has to be a citizen of a different state than the defendant. So if you had a regional bank and who was headquartered in Michigan and a Michigan borough, you could never get federal diversity. So you did have problems if you had a client with, when I did the franchise work, clients with franchises, Taco Bell's in 4 states. So if you did it by state, even to foreclose or to try to take control, you would have to go into each state, and in many cases, each county. Whereas if you could get the federal jurisdiction, you could go into a federal court, get a receiver who would have jurisdiction overall. So there's a lot of differences. There's no commonality to any of the states. And that was, again, the purpose of the Uniform Act, to try to bring some uniformity among all of the states so that everybody would understand how receivership works, no matter what the state is.
And Keith, I'll add to that. I think, Kay's made a good point, and it's great that they worked hard to get this developed, because I think that was the one impediment between receiverships and bankruptcy and so forth, was this issue of selling free and clear. And now that that's been, as part of this act, that's made that decision much easier. And the other thing is, which the case credit and the group's credit, is to add this issue of, rejection of contracts as well. So the impediments that prevented people from choosing between receivership and maybe a Chapter 11 or Chapter 7 have now been really eliminated because of those two provisions, which have been pretty significant. And on the topic of the federal receiverships, that is the one difficult thing when you have multiple locations in different states with regard to selling that property, because most of those states require you to initiate a separate receivership action, which sometimes may not be problematic, but if they're going to appoint a separate receiver in each one of those, it makes for trying to liquidate those assets extremely difficult, which is why we tend to want to go with the receivership. But the act itself now, which allows those things that make the decision between a bankruptcy and a receivership, really easy to make now, simply because they allow for the free and clear and certainly the rejection of contracts.
But would you agree, Gene, that it's really still a remedy? I mean, it's not a remedy generally for unsecured creditors, right? They can file an involuntary. It's a secured creditor.
It certainly is, but I think in many circumstances, and certainly in a couple of the recent cases we've had, where we've by the secured creditor taking that action, the unsecured creditor, and more often than not, is in a difficult situation, without the receivership. But certainly there's a chance, maybe in the context of the receivership, that maybe money flows through to them. We've had a couple of occasions where that's happened. So I think it benefits the unsecured creditor, but you're right, Kay. I mean, at the end of the day, it's the remedy for the secured creditor for sure.
Great. I'm going to skip a little bit. Traci, I'm going to jump to you real quick here, and in terms of your experience, whether it's you personally or your bank or banks in general, creditors in general, when do receiverships really make the most sense? I mean, why would someone say that's the route I want to go? That's the best solution for us. What is taken into consideration when that happens?
Well, I think I would take a step back a little bit and just also point out, and perhaps Kay can touch on this a little bit better too, is that historically, since a lot of the receivership properties were real estate focused, and you had to be able to demonstrate statutory waste, they weren't paying their real property taxes, they weren't insuring the property, it kind of limited the opportunities you had to appoint a receivership, which may have been why we didn't see at least personally, I didn't see it, use it a ton as a remedy. As a workout officer. Now, that being said, if you did have a real estate holding company, for example, that, kind of a single asset situation, they did have past due real property taxes. We had a pretty good loan to value, meaning there was equity in the project so that we could justify receiver fees. This would certainly make sense. It would also make sense in the context if there were environmental problems with the property, something where, once you touch that fly paper, even though Michigan gives you the opportunity through a BEA to help, protect yourself with that, if you can avoid that fly paper altogether and let somebody else step into the borrower's shoes and liquidate that asset, it was just a much cleaner approach. It also helped banks keep these, random assets, these other real estate owned assets off its balance sheet, which we don't want to carry. We don't want to have the carrying costs. But again, in any situation, having for a creditor to seek appointment of a receiver, we are also, even though that receiver is working on behalf of all the stakeholders, we're the ones footing the bill, right? So it's an expensive prospect for us, and we want to make sure that there's sufficient assets and value there to, get us out whole and to help pay for these costs of either a wind down or sale. Another situation that's going to be, make a receiver a really great fit is when we have some sort of fraud. And I use that word in the biggest sense possible. I mean, that could even, it boils down to, we don't trust the borrower anymore. Perhaps we've learned that they've opened a deposit account at another bank and they're funneling receivables to another lender where we can't watch those deposits or perhaps set off on them. They're paying unsecured creditors, things like that. But there are significant trust issues, or the relationship has deteriorated to a point it can't be repaired. So that would make sense. Or if you have a situation where the assets that need to be liquidated to wind down the company, such that it's going to be too much or too expensive for an auctioneer to come in. We may not get access to the facility to auction on site. We can't move those assets off site. To have a receiver in those shoes right there, that would make sense. Also, if you have a receiver that has experience in crisis and turnaround, and that they can actually step in and manage the company to try to maximize value as a going concern, also a great opportunity to put a receiver in than just being lights out and going with the cold asset liquidation value. So, there's just, like I said, it runs the whole spectrum of times when a receiver makes sense or doesn't make sense.
Keith, if I can add to what Traci said, and certainly
Sure.
she's right in the sense that the majority of the receiverships are going to be initiated by the secured lender. And she's right in the sense that they are going to be the ones that are footing the bill for it. The one difficult thing that occurs, and I think this is where it's important that the receiver that you pick understands the role of the receiver as being the independent person, is because there are competing interests all the time in these cases. And despite the fact that the secured lender is the one that's pushing for the receivership and has nominated the receiver, the receiver is not the receiver of the bank or the unsecured creditors or any other party. They're an independent fiduciary for the court. So that carries a lot of responsibility to have to make decisions that maybe sometimes are not in the best interest of the lender. But I think at the end of the day, when all parties' roles and interests are accounted for and discussed and so forth, I think there's another understanding that really it's to achieve what the receiver was supposed to do there, which was to minimize, to maintain the value of that property, minimize any fraud or anything like that, and ultimately, try to receive the best and highest price you can for the property. And I think, that's the important thing about it, that you just have to make sure that you understand that you're really an officer of the court. Your responsibility is to the court, to report to the court, and ultimately, sometimes have to make those difficult decisions. And one of those, to be honest with you, as Traci was talking about, is having a restructuring background and an understanding that there are circumstances where it's maybe not in the best interest to come in and slash and burn and liquidate everything. Maybe there's an opportunity with a cash infusion to keep the business running for a period of time and sell this going concern. One of the greatest things for us is if we can go in there and we can keep the employees that are there and working hard, keep them employed and so forth. And that's a difficult discussion with the bank because they've got to pay for that. But in the long run, you come out of it feeling good in the sense that, hey, we preserve jobs, we preserve the value of the collateral, we kept the business operating and so forth. So there's a lot of dynamics that have to be weighed in those circumstances. But the important thing is having that communication with Traci, having the communication with Kay, who's representing parties and interest, and making sure that everybody understands that, having a budget where they know what the dollars are going to be and so forth. So all of that really is important, that everybody kind of gets together and talks about that.
And Gene, that would be, at least in my experience, that happens before you decide to file a receivership.
Right.
You try to find a receiver, and those discussions and the budget and the monetary concerns are addressed before you file, not after, because after, it's just going to cause all kinds of ruckus, and Traci is never going to be happy.
Right. And you're right, Kay. And the other thing comes because you want to have an order that's drafted that's going to make sure it covers those things that you want to accomplish. And one of the most common things that becomes an issue later on is, what are you going to do with the shell of the company? Say you end up liquidating the company, selling it as going concern. What is the bank's plan? They don't want, presumably, to go through the steps of getting tax clearance, filing all the returns, dissolving the company, because that's on their dime. But those are discussions, as you correctly point out, Kate, those have to take place before, so that all that is incorporated in the order. There's a very clear understanding what the receiver's duty is before you even step into court, whether it's a stipulated order or a hearing on the appointment of the receiver.
But Gene, I also see a difference between having a receiver appointed over a business and having a receiver appointed over collateral.
Right.
Because in my experience, if you're a lender, you want a receiver appointed over collateral. which may be a going concern business. But you do not want your receiver to have to deal with tax returns, pending litigation, to step in as the plaintiff. So in my experience, you try to tailor in the order exactly what the receiver is being appointed over. And if they're not appointed over the business, then neither the bank nor the receiver have that. That's not their problem. It will be the problem of the borrower entity to decide how to dissolve the company. So again, as you stated, the order is the most important thing. When you craft an order, which you want to do with the receiver, with the bank, with the defendant, borrower, and with all the parties, then you're going to be in a much better situation.
And just to follow up on that, I think the other thing that, and this was raised one of the questions is it's important to be in front, and you want to be in front of a court who understands what the statute says and what the statute provides and what the receivership order provides and so forth, because you're going to be in court on those issues. And a lot of times that doesn't happen. And we have very competent state court judges. We have very competent federal court judges, but we also have judges that don't understand that and sometimes want to make decisions just based on the fact that they make decisions that aren't really, relying on what the statute provides as the order. So you're right. And those are, again, those are decisions that you have to make beforehand, but sometimes you just, you can't cover every basis, but you're absolutely right on the collateral versus the operating company for sure.
Well, let me interject kind of and back up a little bit. So Traci talked about circumstances where this might make sense to go into. So, and this can be for any one of you, I'll say it that way. In terms of the process, just from a high level, the process is we start with a secured creditor who's got some concerns. So it starts from there. Can you kind of walk through the higher level steps? You talked about the order of the receivership and then the duties, just kind of, in a little more of a chronological order of how this progresses through the process would be helpful for me anyway.
Go ahead. Go ahead.
Oh, no, you can't. Gene, if you want.
I'll jump in after you guys. You guys are pretty much having those discussions before you maybe contact me. So I'll let you guys say it.
Generally, what you do is you have a discussion with the client. And in Michigan, there is a limited one action rule. So you really can't start foreclosure and get a receiver appointed simultaneously. And as most of the people here know, you have a redemption period in Michigan for commercial real estate, 6 months on the other side of a sale. So in my opinion, and Traci probably doesn't agree, but if you're going to foreclose, you might as well have a receiver appointed, because then you can sell the assets free and clear, which in some cases, even a secured lender can credit bid. So you have to decide what your goal is. Do you want the business operating? Do you want the assets sold? Or do you want to foreclose? Because if you want to start a foreclosure action, then you may be able to get a receiver appointed at some point, but they're not generally done at the same time. So you first decide if that's the best remedy, and you talk through remedies, because bankruptcy is a great remedy, but one, I think it's more expensive, and two, it's usually not initiated by secured lenders. So from a secured lender perspective, you're not usually going to be, because you have to have unsecured debt to do that. So you decide, and once you make that decision, then you talk to the client about who would be most qualified as a receiver. If you have real property involved, you get a title company involved immediately. If you're going to go into receivership, because if you're going to try to sell out of the receivership, you want the title company on board at the point you decide to file a motion to sell assets. So you can get in the motion and in the order, whatever the title company wants, so you can sell those assets and get clean title with a title policy. Because title companies are not as familiar with receivership orders as they are with federal court orders out of bankruptcy court. So I always bring in the title company almost immediately if there's going to be a real estate sale. And then you approach the receiver. You have them run their conflicts. You then talk with the client and you put the business people. To me, the business people are the receiver and the Traci. You put them together to discuss budgets, what the goal is, what you want the receiver to do, how often you want reports, what kind of reports that you want. Those are business issues. To me, those are not legal issues. You just identify them for the client and then let the client have a discussion with the receiver. And then you craft an order and you run the order past the receiver, your client, the receiver, and if you have a friendly borrower, past the borrower. I always run it past borrower or borrower's counsel. They may say, no, we're going to fight you, and that's fine, but at least they're on notice. And if you're in a weird situation, like with franchises or some other third party, you got to get them involved too, like hotel chains or franchisees. If you filed a receivership out of the blue without having any conversations, they're probably going to decide to shut it down. So that's the process. And then you go into court. When you have all of those ducks in a row, at that point, you go into court. And if it's consensual, all the better, because you can do it by stipulated order. If not, then you file the appropriate pleadings and you will have a hearing, and the court will decide, one, if the receiver is qualified, because that's a requirement of the Michigan statute. And if the court is not going to accept the receiver proposed, it has to make findings of fact as to why that receiver is not qualified, and in order to appoint another receiver. That's been tested, that whole system, because there was a Wayne County judge who decided to appoint his own receiver and ignored the Michigan court rule, which has now been incorporated into the act, and it went up on appeal and he was reversed. He had to make findings of fact if he wanted to appoint somebody other than the receiver, if that receiver was qualified. Jean, do you want to add anything to that?
I will. Tracy, did you have anything to add in terms of those meetings beforehand that you wanted to
No,
add?
Kate covered it. The only caveat I would add there is that, there's a difference between a building that's completely gone dark and a building that needs to continue to operate. So, a strip mall, like she said, a hotel, apartment buildings, things like that, where the ongoing management, where the bank's not going to just collect rents and then not pay the utilities and, manage all those things. Those are all great fits for receivership. But if you've got a building that's just, gone dark, unless I said there's other extenuating circumstances like the environmental, some other reasons that you may not want to enter that chain of title, it'd be kind of a toss up between receiver and just a straight foreclosure.
Yeah, and everything that you guys have talked about is really right on par to the to the phone call that we get to to discuss if this is something that we would be willing to handle and so forth. And I think a couple things that I see that come up that I think are really important, really from deciding on a receiver is, number one is I get a lot of calls about have you what areas are you're an expert in and you handle these cases. And the fact of the matter is, in 25 years, I can't think of an industry that we have not been involved in. But I think really what you have to decide is this what are you facing going into? Is this a hostile environment? Are you going to have people removing stuff right away? Is it a cooperative borrower? Because what you don't want to do is you don't want to just appoint somebody because either they're less expensive or you've had them before and they did okay on selling something. When something comes up that you feel you might have to remove them because they're not doing what needs to be done, or they're not accomplishing the task that the order directs them to do. So I think it's important really to have somebody that has some just general business understanding, can assess the situation, is able to assemble the right team of people in order to do to carry out the duties of the order. And that might be a financial advisor, might be a realtor, obviously counsel and so forth. So I think those are important things for us that we look at in terms of making sure that the bank and counsel are well aware who we think that, we're going to need as a team to get in there and do that job. And, so once we've done that and accounts for the receiver, accounts for the bank, get together and talk about the order, draft it, so forth. Then we try to put together a budget, at least get an idea of what we think, on an ongoing basis it's going to be, and certainly make sure that we take our forecast and compare it to actuals as we go through the case. But more importantly, just get an idea of what the bank was expecting, what we think it's going to cost. Have that kind of in place, but understand that that's going to change as things progress during the receivership. And the other important thing is location. Is I'm a firm believer, always will continue to do this, is I want to see the assets. I want to see where the location is. I want to talk to the employees. I want to talk to management. And, you might have multiple locations, and it might require us to go out to different locations, whether it's across the state or in one state, to have those discussions, to look at that, because I think that number one, it provides a good, a better idea of kind of how we think things are going to progress. Number two is it gives people comfort that, we're not just kicking everybody out, but we're going to try to work to either, keep people employed and work toward a sale if we have to, or liquidate. But I think those things are important. So we want to make sure that the bank and the counsel are aware of what our process is when we do that. And then once we're all in agreement on that, then, we leave it to counsel to, to talk, to submit it to the court.
Okay, great. Oh, thank you. Thank you all for that. When we started the session, the description is of this session is to talk a little bit about the new Receivership Act, which kind of sounds like it evolved over time. So I'll jump back to Kay and just kind of what led to this new Receivership Act. I think it went into effect about 13 months ago, give or take a couple of days. Just for everybody to understand what happened to lead to that.
Well, the Uniform Act that dealt only with receivership was enacted and became effective on May 7th, 2018. And again, it dealt only with real estate or personal property related to that real estate.
Okay.
So soon thereafter, there was a movement. It was both through the state bar, Judge Yates, who is a state court judge in the Western District of Michigan, who's very active in this arena, and knows Representative Iden, who sponsored the original bill. There was work done to amend the act to allow it to be inclusive of things other than just real property and real property asset or personal property assets related to real property. The Uniform Commission actually had what they called a canned amendment, where they had contemplated this might occur because it's logical sense that you start with the real estate and then you move on. There were discussions at the state bar that it needed some amendments. So the major changes were it harmonized before the statute was enacted, the court rules were enacted, and the court rules dealt with the selection of qualified receiver, disqualifications, duties, powers, receiver orders, and receiver's bonds. So when the statute was being reviewed by the State Bar Committee, and when it was sent back to Representative Iden, all they did was they took out what the Uniform Act had on those topics, and they incorporated the court rule. Because the court rule had been passed, people in Michigan were used to dealing with that. And so as not to have to amend court rules again, that was incorporated by reference. So this amendment actually harmonized the court rule with the act. And then there were changes in the expansion of some notice provisions. The owner is now required to give the receiver a list of all the interested parties in the case, and then the receiver must give all interested parties notice. There's a provision for a bar date notice, unless it's clear that there will be no distribution. Very much like bankruptcy, you send out a claims bar date notice, and creditors are required to file notice. And there's some specific provisions about reporting. It requires mandatory quarterly reporting, periodic reporting, and what has to be in those reports. Now, prior to that, these are things that I would have built into the receiver order. Again, to me, it's a business issue. What does the bank or the lender or whomever's filing for the receiver want? What information they want? How often do they want it? In what form do they want it? So now there are requirements in the statute that obviously can be enlarged, or instead of quarterly, it can be done monthly, or it could be done weekly, or whatever you need. In a situation where you have lots of tenants, I would think a rent roll would be something that a bank would want to see, or a lender would want to see every month. And that would be important to analyzing and knowing what's going on with the collateral. So that was what led to the amendment. And that's how we got where we are today.
Okay, do those changes, Kay, or whoever would like to respond, does it make it easier or more advantageous to use a receiver versus before this was passed? Was it kind of somewhat of a tipping point? We say, oh, no, it's definitely the route we want to go now because of these changes, or is it not that simple?
I don't think it's that simple, but I do think now it can be used if you don't have real property involved. Whereas before you clearly had to have some nexus with real property. So it was very expansive from that perspective, in my opinion. I'll defer to others as to whether they think it has opened other doors.
Yeah, I think that it was necessary, because I think one of the concerns was just the parties could get together and select a receiver, and then, the judge could really appoint anyone that the judge wanted to. And certainly, want to defer to the judge, it's their receiver. But I think it didn't sit well with practitioners, because, maybe that person wasn't really the most qualified for that role. You haven't worked with them before. So there's reasons I think that the order has provided some comfort with regard to the practitioners in terms of getting a receiver appointed. That's number one. Number two, as I said before, I think the opportunity to provide a mechanism which gives people an alternative other than a bankruptcy. And I've spent 20 years as a bankruptcy trustee, but I will tell you today, I would discourage pushing people companies into bankruptcy. I just think there's other alternatives that are more advantageous for the parties. So I think that this has been extremely helpful in that regard. And the other thing is it provides a lot of protections. I mean, one of the things in a comment was made, in one of our questions here is about, this all stemmed from what these called the trust mortgages that existed years ago. Collateral and appointing a trustee, securing that and recording that in the counties where the property is located, and really giving that trustee discretion to run the business, sell the assets, and operate the company. But there really wasn't a lot of protections for the fiduciary as well as the parties, and there was no court involvement whatsoever. So as far as what actions were being taken, sometimes I think created it wasn't the best of circumstances, let's say. So I think this provides, it lays out in the statute notices, filing inventories, things like that, making sure that all the parties that have interest in the property are notified. I think those are extremely important. And I think also, there's also, protections for the receiver as well. And I think that's important too, because the receiver's got to make decisions that sometimes aren't the most favorable, and the outcome may not turn out the way that you anticipated, but there's protections for the receiver that I think are extremely important. So I think that has been an extremely valuable, process as a result of this, the statute. So.
Okay, thank you. Traci, given the change or the inclusion of, above and beyond real estate, is this something big for the banks and the creditors out there now that this is more readily available as a remedy for?
Yeah, absolutely. I mean, as a matter of fact, I've got one in process right now that is strictly personal property. And again, it's the circumstance where the equipment is so big that it must be sold on site, but the borrower is also the landlord, the different transaction. And we knew for sure he wasn't going to let us come in and, auction this stuff voluntarily on site. So we would have to move it off. Well, the cost to move would be, too great. And so the receiverships being put into place strictly to liquidate assets on site. And that would not have been an option before. So certainly has opened some doors.
And just on that very matter, like before, what would you have had to do to pull that off?
I probably would have had to get a TRO, force them to step aside while I got my auctioneer on site. I would have had to pay big bucks to move. But sometimes even with these, you think about the big presses and things like that, are built into the building and go down into the floor. I mean, the value in place is so much different than disassembled and unassembled and taken apart.
Okay, thank you. We covered a lot of my topics, and I apologize when I'm jumping through my question list. We talked about the types of companies that this best suits, and it sounds like with the passing of the new law a year or so ago, there's no longer a profile of a company that this is best suited for. Is that, do you have any comments on that? Any of you? Is there certain industries this works better for or not so good for?
No, I think.
Well, again, your cost benefit's going to be a key factor, and how much value is there to spread around. That's, and the level of intensity in terms of how much management it's going to take to get to the other side. Certainly, that's another factor.
Okay. All right. That one.
Yeah, I don't think that one industry is better suited than another necessarily. I mean, if you have commercial real estate, you may need it to be able to collect the rents, right? If you're foreclosing on the assignment of rents, then if you put a receiver in place, it's much easier because now the receiver can collect the rents and you're not chasing the tenants to get that accomplished. But I mean, you had that before with the other act. And I think probably you had that before the act was passed, but I certainly don't know because I never used it as a remedy before.
Okay. And that's a good segue into this.
The only thing I was going to say too is, I mean, you talk about nowadays you have to be able to adapt because of the cannabis industry as well. I mean, you have to be as a lender, if you're in that space, always know, what are your alternatives if in fact something doesn't go right. And obviously, state court's an option with that. Federal court wouldn't be, but so you got to just be aware really kind of the industry. But, I would concur with everybody that there's an avenue for any industry. You just have to know kind of before going into it, if something is going to go wrong, where are you going to end up in order to make sure that you can enforce your remedies.
Okay. And this may be kind of a pro and con topic, but what I've heard and what I've read with the new change, some of these rules, it's getting closer and closer to a bankruptcy. And I certainly don't want to overstate that. There are different subtleties to each, but what are, from a very high level, what are the differences versus an 11, a receivership versus an 11 now under the new act?
I think Kay addressed it early on. Obviously, in the context of the receivership, it's going to be initiated by a lender. Bankruptcy is going to be initiated by the debtor, and one of the key issues with that is, to the extent that they're in a Chapter 11, they have the opportunity to propose a plan. I mean, they have this exclusivity period within which they can continue operating, despite the fact they got to, have reports for the U.S. Trustee's office and so forth. Presumably, if they get a cash collateral order in effect and so forth, they're really running, without kind of the same companies essentially running. And if the lender's concern was, hey, we have some serious mismanagement issues here, you've kind of taken that out of the hands of the lender. Now, they could file a motion to dismiss the case, but the court's generally going to defer to the debtor to give them an opportunity to reorganize. So I think that's a concern if you have some issues with regard to the mismanagement, of the company. I think that's a big issue. And I also think from the lender's perspective, certainly where you have a case where there's going to be a committee, and certainly, if it's a subchapter 5 case where the U.S. Trustee's office decides not to appoint a committee, you don't have to deal with that. But where there is a committee, there is going to be some serious negotiations where, money is going to come out of eventually the lender's pocket to solve, resolve issues that the committee has to ensure that they get some, piece of the pie. So those two things to me, I think, are significant enough that, when you add that, those two things in the equation, that, sometimes maybe the answer isn't the bankruptcy because of that. And I think the other things, and Kay, you can correct me if I'm wrong, the new act has state provisions under the Receivership Act, which I think was ultimately the biggest concern. And now there is this staying of litigation, and I think that's obviously helpful because you have that provision in it now. So.
Correct. And the thing about receivership, even if you're a lender and you're moving in and you're on the brink of getting a receiver appointed, or you do get a receiver appointed, you can't prohibit the debtor from, or the borrower from still filing bankruptcy, or for unsecured creditors filing an involuntary. So if unsecured creditors are not happy with the receivership and they think that things aren't being run correctly, they can definitely file an involuntary petition. Now, you can file a motion to dismiss. There's lots of things you can do to fight about whether it should stay in receivership or it should be in bankruptcy. But receivership does not prohibit bankruptcy, and nor does, and again, I speak from my bias is the Uniform Act. The Uniform Act merely sought to codify what was already in common law for receivership as a remedy, not as a bankruptcy statute. So it was never intended to replace bankruptcy or compete, I put that in quotes, with bankruptcy on a state level. So it was merely to codify common law that's been around for hundreds of years. So I see them as different remedies. I see them at different, it depends on the circumstances. It's not a one size fits all. I'm not sure what subchapter 5 now does to receiverships, in that there is no committee. So you now have a way that's faster, supposed to be faster, better, easier. Whether that will have an impact on bankruptcy or on receivership, I'm not sure that it will, because again, the situation that puts you into a receivership is not usually the same that puts you into a bankruptcy.
Right. So there's not an automatic stay provision of any kind when a receivership is put in place, or
There is.
Is there? There
Yeah.
is. Okay.
Under the new statute that provides a stay, which is extremely important now because that was not an issue before. So.
All right.
Yeah,
So
before you
there-
used to put it in your order, that you would put it in your order appointing the receiver. You would have an injunction in there prohibiting creditors from doing anything
Right.
against the receiver for pre-receivership action. So yes, now it's in the statute. Before, you just put it in your order.
Okay, but those same creditors could then force it into a filing in Chapter 11 or 7, under whatever circumstances that may be. So,
Correct.
and that's really the reason I asked that. There is an automatic stay, but they're still allowed,
right,
to push it into one of the chapters.
Yeah, there's actually well, this came out of the federal receivership, but there's actually a Fourth Circuit case from the Fourth Circuit
Okay.
in a federal receivership context, because there was a fight. There was a receiver appointed in federal court with that injunction. Receivers filed an involuntary. The judge in the district court said you can't do that. And ultimately, the Fourth Circuit said you cannot take away the ability to file an involuntary or to file a bankruptcy case, because that's the federal supremacy law. So you cannot, even with the automatic state, you can't stop the filing of a bankruptcy petition.
And I will, certainly, obviously, when drafting the legislation, and I was a part of drafting it, but there wasn't the intention to replace one with the other. But I think from a practitioner standpoint and a practical side of it, I think I'm not suggesting it replaces it, but it certainly becomes a more balanced playing field in terms of making decisions, which I think is extremely important. And there are circumstances where the bankruptcy is going to be better, and there are circumstances where the receivership is going to be better. But the other thing is, and we've had this with many cases where if a debtor attempts to file a Chapter 11 or a bankruptcy while the receivership is pending, the bankruptcy courts have deferred to the receivership in the sense that has been in place, and there's no basis for the receivership to be displaced simply because the debtor wants control of the company. So even though that doesn't, it doesn't prevent them. I mean, a court's not going to simply, if the receivership's been in place for 3 months, 6 months, isn't going to automatically, okay, you have the right to be in a Chapter 11 now. That's not going to be automatic. So that's happened in a number of different cases. And back to the involuntary, you don't want to take that right away from people, but I do find that in communications with creditors in the context of receiverships, I think most often, if there's concern over the mismanagement and they feel comfortable with the receiver in place and the receiver experience and so forth, that they just want this opportunity that there's some oversight and
Sure.
is potentially going to get out of it. So those are all things that are worth discussions. But from a practical standpoint, I think overall that this has kind of leveled the playing field is providing alternatives for a bankruptcy. And I think that's great.
Okay, and then that, it sounds like there's pros and cons, just like there is to every course of action. And thank you. But Traci, do you see any other pros and cons, at least from your side of the aisle?
Oh, yeah, I mean, for me, it's a much more efficient means to handle a wind down or even any sort of sale. There's a lot more transparency. We usually have relationships with people like Gene. We know them, we trust them, we've seen their work. So those are certainly some of the pros. And again, for the cons, just looking at my notes, again, the cost is always a huge factor for me, but I can tend to be kind of cheap. And then also, like I said, but this could happen in a Chapter 11 where you've got to continue to lend into it. And that's kind of the rule number one at loan workout is we don't want to dig the hole any deeper. And again, because the receiver isn't, while we may have brought this about, they're not working strictly on our behalf. So that receivership could drag on those types of issues. So again, I'm just kind of rehashing some of the same high points we've already talked about.
And even though they created the Chapter 5 to really make the process easier, the fact that there's not going to be a committee and there's no quarterly fees by the U.S. Trustee's Office, I agree with Kress, Kay. I don't think that that's going to alter your decision on a receivership or not. I think there's other factors ultimately that are going to play into that, and sometimes these are smaller cases that maybe it's not even practical for the appointment of a receiver. But I haven't seen that to date where there's been a change simply because of the Chapter 5 provisions now.
When I was representing lenders, I would actually use the receivership sometimes for this reason. Either I got a receiver appointed, or the borrower was going to file bankruptcy, or the borrower was going to come to the table. But if you had a stalemate with a borrower and a secured lender, and the borrower was basically thumbing their nose at the lender, at least you made progress, because they can't just sit, right? They have to do something.
Right.
And I had several cases where the borrower thought filing a bankruptcy was going to be their savior, and it just allowed the lender to take control more quickly, more easily in the bankruptcy court because of this mismanagement. So bankruptcy is not a panacea for borrowers, and they sometimes perceive it. Okay, they're going to file the Chapter 11, they're going to stop the receivership. So you get it. I was not always unhappy to have them file a Chapter 11, because that gave me the forum that I needed to get where I needed to go on behalf of the client.
Well, and let me add to that too, Kay. Even if we take it out of the Chapter 11 context and let's talk about a Chapter 7, I think, and Keith, this would be relevant to what you do. If you're sitting as a CRO in a case and you get to the point that you're toward the end of the case, or maybe you have a road creditor or something which is going to force you to have to do something. And sometimes, the discussion is, well, let's just, when we're done with this, let's just flip it into Chapter 7. And again, having served as a Chapter 7 trustee, I know really the Chapter 7 trustees, we're not going to leave any stone unturned. And if there's potential, liability claims, there's potential, D&O policies that against existing board members or prior board members or whatever the case may be, that opens up a can of worms as far as those issues go. And so sometimes you have to really kind of walk a thin line in terms of really, is it better to be in a Chapter 7 bankruptcy in a case like that? Or is it better to, for either, wind everything down in a receivership, or, we're not talking about ABCs right now, or an ABC where there's a little more control, so to speak, in terms of an orderly, kind of wind down, so to speak, of that company. So there's a lot of things that you have to really, really juggle. And it's worthwhile to speak with somebody, like Kay or myself, or, Traci, that has had the experience. Like, what have you seen in these scenarios, and what is your recommendation, or what is your thought? Because that could change dramatically from case to case, and it shouldn't just be a one-stop, this fits every case. So I think any chapter in bankruptcy, you got to really evaluate whether or not it's the best alternative versus other fiduciary roles.
And you just made an excellent point, because there is nothing in the receivership statute that gives a receiver the ability to sue for preferences or other kind of causes of action that you would consider Chapter 5s. Of course, you always have state law fraudulent transfer statutes, but you don't have the bankruptcy Chapter 5 causes of actions in a receivership. So that may or may not be a good thing, depending on where you are and if you want those pursued. So that's a huge difference between receivership and bankruptcy, is the power that the receiver has to chase others outside of a bankruptcy context.
That's great. Lots of stuff. We'll make sure everybody's got your phone numbers. We're getting close to near the end, so I wanted to give each of you an opportunity to tell your war story, because I find these interesting because they're real life situations, and you know, take the time to describe kind of what happened for better or worse as we go through. So I know Traci, I know you said you had a good one, so we'll get you.
Trying to keep it to 90 seconds or less will be the challenge here, but. Yeah, we had a self-storage facility, and just to give you a little context, this was just as the recession was gearing up, and there was a builder that was out of business, and his family had 2 existing self-storage facilities, and they said, look, son, why don't you build us a third? And so the son went and applied for the financing, did it all himself, and we got the appraisal done, and the as stabilized value supported the loan. However, nobody looked at the fine print and didn't realize that the stabilization period was 8 years out. And so when he built this facility, he flooded the market, including his parents' 2 other self-storage facilities, and all 3 of them came down. So it didn't take long. He didn't get stabilized, past due real property taxes, no insurance, things weren't being paid, past due utility bills. Boom, let's get a receiver appointed. Let's go. So the hearing for the receiver was scheduled for May 5th. And of course, he had plenty of time to reach out to all of his existing tenants and to even put advertisements out saying that he was actually facing foreclosure and that he was implementing his very own bailout plan. And what he offered was a buy one, get one. Buy 1 month, get 1 month free. Buy 1 year, get 1 year free. Whatever it was, but it had to be paid in cash and it had to be paid prior to May 5th. And so when our receiver finally got in there, first of all, we found out that he had done huge destruction to the property, over $250,000 worth of physical damage to the property before he left, taking his pound of flesh. But then the receiver gets in there only to find out that these contracts exist. And we basically have a property that's not going to have cash flow for many, many, many months. So fortunately, the receiver went in and talked to all these people and said, look, we'll honor the buy one part, but the get one's off the table. So if you bought 6 months, you'll get 6 months, but you're not going to get the additional free. So eventually there was some light at the end of the tunnel that this would start producing cash again. We could get it sold. We then got it sold and had quite a significant deficiency, for which we sued the borrower owner and got a judgment. And we called him in for a debtor exam. And we asked, what happened to the hundreds of thousands of dollars that you collected on this buy one, get one free plan? And he says, well, I took it to Soaring Eagle Casino, had quite a weekend, thought that I'd win it all back. Well, what happened? I lost. Hundreds of thousands.
That's a perfectly reasonable response, trying to win back that way.
Yeah.
Do that, right?
Mm-hmm.
Gene, how about you? You got a good one for us?
Well, I of course, I don't have any horror stories or bad stories because I think we pretty much do a really good job in every case that we have. I'm not sure I could pull something that would top that story, but what I wanted to do, just take a couple seconds. I did get a call. This is a few years back from somebody that was involved in a case. There was another receiver involved, and they asked me about these DTE energy bills that were incurred post receivership and how they're supposed to be handled, because the number got to be in excess of $350,000. And it was somewhat shocking to me, because I think that's the one other thing that people have to be aware of, particularly the lender and the counsel, is that if you have a receiver that doesn't understand the difference between administrative expenses, priority claims and things like that, it can be really costly. And unfortunately, a situation where you're incurring costs post receivership, assuming without any regard to whether or not you're going to be responsible for those, is a shock that you have to present to the lender. And unfortunately, I didn't have to break the bad news. It wasn't my case, but they didn't like the fact that, that they had to explain to the bank that, they incurred these charges and didn't explain to the bank. And that was something the bank had to pay. So I think it's important to have somebody that really understands that the difference between, what an administrative expenses that you're responsible for after the filing. The other thing is, and I want to just take another couple seconds, is there's always the tax issues that come up, and there's questions about what do you do as far as tax returns and so forth. And I know to the extent there's any accountants out there, they're going to tell you that if there's any taxable event, make sure that you've got, tax returns filed, you've got a EIN number and so forth. In the majority of cases, we do that, but there are circumstances where if we're just simply liquidating something, we might do all the work necessary, provide all the information to the existing accountants so they can do their final returns and really not get the EIN in those circumstances. So I don't think it's a hard and fast rule, but it certainly requires, again, you better talk with an accountant who knows what they're doing and rather than, try to walk through it yourself, because it's a very difficult thing. And the other thing is being familiar with things like the WARN Act, the PBGC, if there's 401ks and things like that. I mean, those are landmines that if you step on, that's not a fun discussion that you want to have with Traci about that. And believe me, I've seen horror stories like that. But the good news is we haven't had those situations, so we usually do a really good job. So, but that's the extent of what I wanted to say on that topic.
Okay, good. Kay, how about you? I know you mentioned you had a strange one.
Well, I had a strange one. First, I want to tell you we were creative in one. We actually represented the landlord in a building where the lease required a build out of the lobby, and the owner of the building had not complied with that provision of the lease, and the lobby looked like a war zone, and it was the headquarters of an international company, and they had their senior management coming in from Brazil and walking through a death trap to get to the elevator to get upstairs. So we were able to use the Receivership Act as a tenant to get a receiver appointed over the premises. And unfortunately, Traci won't like to hear this, but over the objection of the lender. So we were able to do that. Eventually, the lender credit bid in, so they got their property back through the sale of the receiver, but the lobby was able to get built out so that the tenant was able to get what they had contracted for in their lease. So that was a creative use of the Receivership Act and not by a secured lender. We also had a case wherein an individual was appointed, a receiver was appointed over an individual who was in a divorce proceeding. And our client was involved in about a dozen LLCs with this individual. And neither the judge which is a state court probate judge, nor the receiver understood anything about commercial law, and actually ruled against us, saying that the receiver not only had control over the membership interest, but had control over the LLC property that prevented the lender from taking any action. And we bought the debt as a member because we had a guarantee. So it was a nightmare. We eventually settled it, but we had a case pending in the Michigan Court of Appeals. So the nightmare is if you get in front of anything but a commercial court judge, you probably are going to have difficulties if the judge doesn't understand commercial law.
Okay, well, thank you. I am quickly looking through the Q&A and chat file to see if there's some areas that have not been covered. So just taking these in order, this was from early in the presentation. Gentleman was looking for a comment on the trust mortgage concept promenaded by the late Stuart Hertzberg.
My senior partner, I started practicing with Stuart Hertzberg.
Yeah, and my good friend Jim McTevia, I think, is the only one that still does them. God bless Jim. But I think I kind of touched on that recently or a little bit ago. I think in Kay, I don't even know when the last time you saw one is, but those were
Jim McTevia.
Yeah, those were used tremendous amount of time by guys that that started this practice and really started the restructuring and the receivership practice and so forth. I think what Kay and her team has done with regard to the legislation now has really helped both, from protections for the receiver, notices and protections from creditors and so forth, and noticing, and then getting a little bit of court involvement on the free and clear sales and things like that, I think has really, been helpful in that regard. The trust mortgage has no court involvement whatsoever, zero. And I think that's the only, that's the issue that you worry about is that sometimes you're going to need a court in certain circumstances. Some buyers are going to want a court order. And so I think what Kay and her team, has done with this legislation has really made it much more comfortable to do a receivership and in that process. And I think the ABC somewhat mimics the trust mortgage, but a little bit more court involvement than a trust mortgage. But those guys started the practice, so they knew what they were doing.
Gene, the last time I saw a trust mortgage, in fact, because there is no statutory authority for it, and there was a creditor who was contesting the validity of the trust mortgage in court.
Yeah.
And of course, we ended up buying them off so that we could continue with the trust mortgage. But that's the last time I saw it, because there was a creditor willing to go into state court to contest the validity of it.
Right. Well, if the next time we have a discussion or topic or a panel like this, we can talk about the ABCs, which I think is kind of between the receivership and the trust mortgage becoming more popular. But I think those help with the court involvement a little bit. But yeah, the trust mortgage, those guys started that and they did a great job with them. But I think it's kind of ends with those guys.
Okay. This next one's probably a relatively quick answer. Has there been any pushback in the state of Michigan on the concept of a sale free and clear, as well as the rejection of contracts? So in receiverships, is there any pushback that any of you have seen?
From the court's perspective and what we've had, we have not had any. That's
okay.
That's gone smooth.
I haven't seen any either. I mean, it doesn't mean that there hasn't been any, but I have not seen any.
Okay, this one I'm going to direct this towards Traci initially. How does a lender handle a situation where you feel the court-appointed receiver is not exercising their fiduciary responsibilities? What would you be doing? I guess.
My first phone call would be to my legal counsel to see what my options were. But beyond that, I mean, I rely so heavily on legal counsel to point us in the right direction. But again, usually those receivers that we're working with, these are not unknown quantities. I mean, we've dealt with these people. They're in the turnaround space. We know them. We've seen their work. And we typically work one-on-one to get to the point where we've joined hands and we're doing this process together, right? So hopefully, that our relationship hasn't deteriorated to the point that we need to start rethinking options.
Well, I'll ask the legal question. If this were to happen, what is the process to address it?
Unwind. Yeah, I would turn that over to Kay.
Yeah, Kay.
Well, it depends on the reason that you're unhappy. If they are breaching their duties of some sort, then I think you have to bring it to the court's attention and you have to file a motion. If you just don't like what they're doing, but it's just because they're making a different decision than you, then unfortunately, I don't think there's much you can do because the receiver was appointed and you don't control the receiver. But clearly, if there's gross negligence, willful misconduct, mismanagement, you could absolutely bring it to the court's attention.
And right, and there are provisions to appoint a successor trustee where those circumstances occur, but Kay's right. I mean, there's got to be real reasons that are justified. And Traci's right too. You don't even want to get down that road. I mean, you know the circumstances. You want to hire people that you feel comfortable with, that that can handle the job. They're not over their heads. And I think that's the benefit of this statute, that it allows those parties to have those discussions so that they can go into the court with a recommendation of who they feel is competent to do that. And hopefully, you eliminate those situations arising.
Okay, thank you. I'm flipping through the rest of these. A couple comments on federal receiverships are the way to go, and I both that was mentioned earlier. I just wanted to raise that for everybody else.
Well, and make sure that we convey that. I mean, Kay and I prefer that, and for different reasons or similar reasons. But again, it doesn't mean that that everybody should just automatically go to federal court, because like Kay said, there's preliminary procedural issues you got to get past before you can even
sure
go down there.
And my last receivership was in in front of a federal judge who didn't want to make a decision, including a sale free and clear decision. And luckily he got pulled into a criminal trial, and we got a different district court judge who didn't have any problem with the sale. So in any court, you're going to be subject to who the judge is. The judge is going to make the difference in any court.
Another thing with that too is if to the extent that you're in a federal receivership, maybe it's an agency of the federal government too, and there's other, competing interests going on, you've got to really know, again, I can't stress about knowing what you do, because there's a necessity to enter into coordination agreements. So you spell out what each party's role is and so forth. All of these things to take place before you even go down that road, because you don't want to be in the midst of a case like that and be blindsided by the fact that there's an agency that's involved in this and there's no assets for you to administer. It's just not a good role to be in. So there's reasons we like it, but with the statute, that Kay and them have put together, it makes it advantageous to be in state court as well too. You just have to really, with counsel, weigh those options and make sure you choose the best one.
Okay, great. And then there was just a couple general comments about the importance of a well-crafted receivership order. And I know you each have touched upon that, just emphasizing how important that is right out of the gate to set the stage.
And I don't mean to be jumping in all the time, but as these come up, it's really funny because there's a lot of time, I'm sure Kay has seen this and Traci has seen this too, is that people take different orders and they add orders. And then all of a sudden you find out that somebody submits it without reading it, and it's got just duplicative statements. It's got competing statements. So even though it's great to use orders from other people in language, somebody's got to read it and make sure it makes sense, because that's embarrassing if you have to go to court on your order and say that you want to do something, but the order doesn't let you do it. And it's, so you want to make sure that the order is important, but somebody's got to read it.
Right.
You can always, I've seen this happen where a receiver gets in either consensually and there is some problem with the order. You can go in and request that the receiver can go in and request that the order be modified to resolve whatever issue is being raised.
Well, I think going through the other comments and questions, I think they were all covered throughout the presentation. With that, I know we're a little past our time. There's so much to talk about. I hate to do this to everybody, but I think we're gonna have to cut it off. Maybe we'll have to have a part 2 one of these days. I don't know if the interest is there. I want to thank my panelists for being involved in this, and I think all 3 of you made me look good, which is not easy sometimes. So thank you. All those in attendance, thank you for joining us. We have a couple TMA events coming up. The big one, hope to see you in person at the holiday affair in Royal Oak in a couple, 3 or 4 weeks. So that being said, we're going to sign off. And again, thank you everyone for participating.
Yes, thanks for joining us.
Thank you.
Thank you.
All right, take care. Have a good day.